Thank you, Virginie, and good afternoon, everyone, and welcome. I've been asked today to give a brief overview of the legal dispute resolution landscape with respect to the energy sector. Before getting into the dispute landscape, I think it would be helpful to quickly talk about the sector itself, and the key feature being that it is heavily dominated by the government and government entities. In terms of the energy sector in Pakistan, basically they have upstream, midstream, and downstream. The upstream sector basically involves exploration of hydrocarbons, and there is some private sector involvement, but it's still based on a concession system from the government. The midstream is almost completely government owned, and downstream, the sector consists mostly of power projects, thermal, hydro, solar, and wind. There is private sector participation, as I said, but all power purchasers or off-takers are government-owned entities. So this is something that's different than what you'd find in the US or Europe, where the sector is largely privatized. So in Pakistan, the main actor is the government, and I think that's a key takeaway to keep in mind when looking at this sector with respect to disputes. The government, because it oftentimes doesn't have the funds to invest in large infrastructure projects, it has to rely heavily on attracting private sector investment, and this is where most of the disputes arise. With respect to the disputes and the framework regarding these disputes, most energy projects in Pakistan are done under either a government-to-government, what we call a G-to-G umbrella, meaning that there is a government-to-government framework in place, even though the project may be carried out by a private entity. Outside of that, then you have a purely private framework, and this framework has important consequences for how the dispute resolution mechanisms are handled. In the government, in the G-to-G framework, the host state or the government usually favors trying to bypass international arbitration in favor of government level talks and mediation. I think CPEC is a good example. There have been a lot of delays, a lot of issues that have come up. But as far as I'm aware, none of the CPEC projects have actually gone into formal international arbitration, and most matters have been dealt with at the government-to-government level talks. I think the government has been successful in pushing forward this model where there is a G-to-G framework. Where there isn't a G-to-G framework, where you have government versus private investor disputes, I think then the relevant framework becomes either ICSID or International Commercial Arbitration under the New York Convention with an international seat. In terms of drafting stage issues in the energy sector, I wanted to discuss some of the prevalent issues that may arise. One issue that has recently arisen is regarding waiver of sovereign immunity. As you know, sovereign immunity protects the government from being sued in a foreign jurisdiction. In this regard, in a recent project, the government has taken the position that it will not waive sovereign immunity. This has important ramifications since recognition and enforcement of arbitral awards in a foreign jurisdiction would normally be protected under sovereign immunity. So as practitioners, I think we have to be mindful of this. We're representing a private party. I think you should make sure to negotiate a robust sovereign immunity waiver clause, or otherwise understand the consequences and explain those to your client. Another key drafting stage issue in the sector is choosing the forum and seat of arbitration. Governments, especially the government of Pakistan, have generally had negative experience with international arbitration, and their view is that international arbitration tends to favor foreign investors and also that the frameworks are biased against host governments in favor of foreign investors. Therefore, there is a growing trend in this sector to try to bypass international arbitration altogether through G2G frameworks, which I discussed previously, or recently even trying to have power-related disputes resolved by other means. For instance, have NEPRA act as a de facto arbitrator. Alternatively, a recent trend is to agree to international arbitration but insist that it be governed by Pakistani law or with the seat in Pakistan. This, of course, poses a lot of challenges, which was discussed in the previous panel. So things to be mindful of is that private investors should ensure binding institutional arbitration seated abroad. And if you're representing the government, I think definitely they prefer other avenues of dispute resolution. I think I wanted to touch upon some other prevalent issues at the dispute stage. Most disputes in this sector arise out of, it's basically contextual. Each dispute has its own facts, but if we were to try to get at a core issue that's plaguing this sector, I think it would be payment defaults and a lack of funds to pay for these infrastructure projects. And this core issue leads to a myriad of disputes where there's delayed payment of invoices, and also the government from its side raises a lot of collateral disputes to defend itself and also to seek maybe leverage in trying to renegotiate the prices and the tariffs under which these projects were first agreed to. And so in conclusion, I've tried to present a very general overview of the landscape of the energy sector as it relates specifically to arbitration. A few takeaways. The key player is the government. Disputes mostly revolve around host government versus foreign investor issues. International arbitration is probably the preferred method of resolving such disputes. Since most disputes are with the host government, parties are unlikely to trust the local court system. So ICSID, New York Convention, and possibly other multilateral treaty frameworks, I think, provide the best framework for investor protection and enforceability across multiple jurisdictions. However, the recent trend in Pakistan is to try to avoid this framework or soften its effectiveness through maintaining sovereign immunity or domestically seated arbitration. Thank you.